All right, and we begin straight away. My name is Safina Chieng Oma, and our sign language interpreter tonight is Byron Apuli. Our top story tonight: civil cases cannot be instituted against the president since he has absolute immunity. According to the legal team representing President Uhuru Kenyatta in the ongoing BBI Bill appeal at the Supreme Court of Kenya, instituting civil proceedings against the president or anyone holding the office of the president will distract him or her from performing their duties, as well as interfere with the security of the nation and dignity of the presidency. Sarafina Robi begins our bulletin.
The second day of the Constitutional Amendment Bill 2021 BBI hearing at the Supreme Court kicked off in earnest before a 7-judge bench led by the Chief Justice Martha Koome. President Uhuru Kenyatta, through his lawyers, led by Waweru Gatonya, will kick off the Wednesday session, disputing a decision of the Court of Appeal and High Court that he can be sued on civil matters.
If it were that it was allowed for every Tom, Dick and Harry to file suits against the president, it would distract him from performing the more important duties for running the state. The President of the Republic of Kenya, or the person performing the functions of that office, enjoys absolute immunity from civil proceedings during his term of office in respect of anything done or omitted to be done in the exercise of the powers under the Constitution.
Court of Appeal has said is that while even companies have the right to enjoy this right, the president does not have. Why? Because he vied and was elected. With respect, that is stripping of his rights. With respect, that conclusion is wrong.
The council argues if civil cases are instituted against the president, it will interfere with the preservation of the national security and dignity of the office of the president.
One would wish that it will never come to a point where a court would order the president to make a disclosure. Why did you do this? What are the reasons that made you make this decision?
Activist Isaac Alocher, whose appeal roped in the president in the consolidated cases, agreed that the president can initiate a popular initiative, but he should not use state machinery on the same.
As an individual, can initiate any amendment to the Constitution, no problem. But just don't exercise state authority in the process of so doing. Don't use public funds in so doing. Don't use public facilities in so doing.
On whether the basic structure doctrine applies, different parties will give their opinions, with some seeking for the Supreme Court to clarify.
It is my answer that the basic structure can only be altered through the primary constituent power.
Third appellant Morara Omoke emphasized on the need for separate and distinct referendum questions.
The electoral system should be able to enable simple voting, efficient voting that is seen as transparent and accountable.
I've already given the submissions, including the respondents supporting the first two appellants, who are the Attorney General and the Independent Electoral and Boundaries Commission. And now we await to see the other respondent, as well as responses to the submissions that have already been made. And then later on, the 7-judge bench will retire to go write the judgment. Sarafina Robi for Prime Edition.